This is classic pseudo-legal rhetoric, often associated with sovereign citizen-style arguments. Phrases like claim notice of non-acceptance, book of registries in Boston, and demands for proof the judge is bonded and insured have no basis in Kansas criminal procedure. Courts across the country have consistently rejected these filings as legally meaningless. The judge immediately asks for statutory authority, because in criminal court, procedure is governed by codified law, not self-created declarations. When a defendant cannot cite a statute or rule, the argument collapses.
Can I say something? I'd like to get can I say something, please? I'd like to put a claim notice of reassurance, a claim notice of non-acceptance, and also reaffirmation of the facts, and a claim notice of discontinuance.
What statutory cite do you have for each of those?
I don't have a statutory cite. It comes out of law books.
Well, law books all have statutory.
What I'm saying, what I'm addressing is the claim notice of reassurance and the claim of acceptance is whoever the practitioners of the law, they're actually registered in the Book of Registries in Boston. And I would have my defense attorney put in these claim notices in paper as well. I've already gotten as oral statements.
First of all, sir, I show that when we were here September 29th of 25, you and Darren Patterson, who had been attorney to represent you, had some issue come up in which he asked to withdraw, and it was granted. He withdrew. I asked you if you wanted another attorney appointed, and you told me you were going to hire your own attorney. So we set this over to allow you to hire your attorney. Where is that attorney? I don't show any attorney has entered his appearance to represent you today.
Because I haven't. I say he's on a retainer fee. He says we have a deal worked out. He's retained.
Well, I'm not sure that he would agree with that, because when he's retained, he shows up and enters an appearance. He sent one of his associates to cover for him in another case today, and that attorney said that they only had that one case and they left. They didn't say anything about representing John Hanna, and they haven't put any notice in file that they're representing you. So it sounds to me like you have not worked out everything you need to with Attorney O'Hara.
I mean, you can say that if you want to, but I would like to address the issue of claim notice of reassurance, claim notice of acceptance, and also claim notice of.
Sir, I've been in the
non-compliance. A claim notice of non-compliance.
There is no such thing, to my knowledge. No such.
I know it's not. That informs me that if you're not according to when you take these law tests, if you don't know what a claim notice of non-acceptance is, that you have to be accepted, you only can take this test 3 times in a lifetime to practice law.
Sir,
so I would like to continue with a claim notice of the proclamation of facts, a proclamation of affirmation of facts, a proclamation of discontinuance, a proclamation of non-compliance for not ensuring me that you're ensuring the bond to do what you're doing, and I like to put a proclamation points of execution.
Sir, there is no such thing in Kansas law. You said you got those out of some Boston law books.
Okay, no, I say Boston law books. I said registry, and the Book of Registry is in Boston. I didn't say Boston law books. I said the Book of Registry. And all I asked for the 922G, if you're insured and bonded to do this, because you have to do it according to federal procedure, according to the United States Constitution. If you can't, then there's no jurisdiction, it lacks evidence.
All right, Deputy, are you there?
Yes, Your Honor.
So is he on a waiting list for a competency evaluation?
And the state cannot recommend me to a mental hospital. Thomas Bradley, First Kansas.
Your Honor, I'm not aware that he's on a waiting list or anything, but I can tell you that he is currently being housed for the United States Marshal Service.
All right. So, Mr. Baca,
so talk to the Director of U.S. Marshals.
Mr. Baca, you believe that a competency motion was filed or just discussed?
Your Honor, I believe, I'll check the filing cabinet. What I'm looking at to start is the pretrial.
This is where the hearing shifts from disruption to due process. A competency evaluation had already been ordered, meaning the court previously had reason to question whether the defendant can understand proceedings and assist in his defense. Under Kansas law and constitutional due process standards, a case cannot proceed if competency is in doubt. Even if the defendant insists he is competent, the court has an independent obligation to resolve that issue before trial. Everything stops until that evaluation is completed.
That we had in September, the notes indicate that the court ordered a competency evaluation on its own motion. The state was to prepare the journal entry on that date. I believe we prepared that. We've also sent that to the state hospital. As I stated earlier, we did check with the state hospital today. While they received everything, it was on them that they had just overlooked that they needed to do this eval. They have notice of it now, though, and are going to be getting on top of it.
So your suggestion in setting this over would be for what type of hearing?
Your Honor, I do believe if we could set it over for a status just to check for the competency evaluation, take it very likely off the jury trial docket, that would be my recommendation. I think probably nothing less than 60 days, knowing how the state hospitals have their time in the past in getting those done.
I just took a competency evaluation at Butner. And when I went to Butner, you raised my bond for me being transferred to Butner. They raised my bond when you transported me somewhere. Raised my bond when I was in Butner and came back, and you raised my bond on that. I was found competent, and I did very well on the test. Like I said, this is insulting my intelligence, man. It really is, because like I said, you haven't addressed the non. If you saying the 920, I asked for your 922 G. If you're reinsured and bonded, and I asked Your Honor as well if you have a 922 reinsured and bonded, and you never addressed the issue. So I'm putting a proclamation notion of discontinuance for this. I don't. But I guess the third time I've said this.
Well, sir, I think I need to do.
This is judicial control restored. The judge does two critical things: continues the competency order and reappoints counsel. When a defendant claims to have retained private counsel but no attorney enters an appearance, the court cannot allow proceedings to drift. Representation must be formal and on record. By appointing new counsel and setting a firm review date, the judge protects the defendant's Sixth Amendment rights while keeping the case moving. This is how courts handle legally irrelevant arguments, not with debate, but with procedure.
A couple of things. I need to make sure you get that competence evaluation, and I'm going to continue with that order.
You can't do it.
And I want to reappoint an attorney to you because you told me you were going to hire your own and you didn't. You told me today you have, but I don't believe you have from what I've seen out of the office you said you hired from. But first order of business, when can we do, Jen, a competency evaluation about at least 60 days out?
You take all money from me.
Your Honor, you do have an opening May 11th.
At 9 o'clock?
Yes.
All right, let's do May 11th at 9 a.m. in order that he be brought back or that he reappear May 11th at 9 a.m. on that follow-up of that competency evaluation. And when he gets back, well, I can't appoint our public defender contractor because you're
not addressing the issues. Definitely. She's supposed to address the issues. Thank you.
Jen, Jen, do you think that normally I would turn to Mr. Josh? I turned to Josh, but I don't think he's taking those anymore. I think he's got other responsibilities. I don't know if Cooper's would be able to fit one in, but I would like to reappoint. We don't have a list for misdemeanors like we do felons, right?
In the past, Josh cannot take any more appointments.
That's what I thought. Yeah, I used to.
Before.
Say that again, please, that last sentence.
You have appointed William McClendon before, or Chris Pate.
Try William McClendon. I don't want to burn him out on it, but yeah, let's try William McClendon again. Or you said Pate. If Pate would take, you might want to try Pate first, just because of the experience factor and nothing more. I think Mr. McClendon can handle it, but like I said, I don't want to I think, anyway, saying less than more, either one of those two would be fine. And we'll set this over, Mr. Baca, to May 11 at 9 a.m. to reevaluate that competency or to review it.
Thank you, Your Honor.
You're welcome. And hopefully, now that you've got the state hospital's attention, busy as they are, they'll make room like they told you they would. So, all right, Deputy, thank you for bringing him out. He's remanded to your custody, to the sheriff's custody.
And Judge, I have Deaton Whiteside at the jail.
All right, when you guys get a chance to bring out Deaton,